Are you Nasir Brown?
Nobody in the room.
I'm
I
sorry.
think we were here before.
You've been here before, but you have to speak up where I can hear you.
Executing beneficiary of the trust in hand.
Of the trust of what?
Of the trust in hand, yeah.
Of the trust in hand? Whose
Yes.
hand? What trust?
The execution.
Did you bring a copy of it?
I wasn't able to get to the copy. I do have.
Take the glasses off. I need to see your eyes, please.
These are my prescription glasses.
That's okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. You were already here and I gave you an opportunity to try to go hire a lawyer for your two cases. Did you get a lawyer hired?
Able to do it.
Who'd you talk to?
Made a few calls to the guy, Rafe. What's his name? Rafe King?
Mm-hmm.
What's his name again?
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made an attempt.
You made an attempt? Okay. Did you go?
Right away, the judge is testing something crucial. Compliance.
So if you chose him, you should have gotten him.
Courts don't just look at the
he has
charges
the
against
same,
a defendant.
there's somebody
They
that
also
answers his phone
evaluate
every
whether
week. I
someone follows
understand.
court
I know how
instructions.
it works.
Missing
I told
deadlines
you to
or
hire
ignoring
someone
orders can
or
have
visit with at
serious
least 3
consequences.
lawyers.
Made an attempt.
But here's the question.
You made
Was
an
this
attempt?
confusion or outright defiance?
Okay. Did you go see Mr. Kimler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position to go back and forth in front of a lawyer that's in this state that I'm not from. This is formal age.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say. Because you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started being
Don't make me lay hands on you.
Why would you lay hands on me?
Because you're not doing what I'm telling you. Now go.
Mr. Brown, you need to go back with the bailiff. Right now, I've raised your bonds. You have to go with the
I am not
bailiff.
a threat to any officer.
You through in, Judge?
Yes, I'm through.
And this is where the tension spikes.
Back with the
Bond
bailiff.
isn't simply a get out of
Don't
jail
make me lay
fee.
hands on
It's
you.
meant to ensure a
Why would you
defendant
lay hands
returns
on me?
Because
to
you're not
court
doing
and
what I'm
follows
telling you. Now
conditions
go.
set by the
Mr.
judge.
You need to go back with the
From the
bailiff.
court's
Right
perspective,
now, I've raised your
failing to follow a
bonds.
direct order
You
can
have to go
signal
with
a
the
bigger
bailiff.
problem.
Threat to any officer.
But do you
through
think
in, Judge?
increasing
Yes,
the
I'm
bond
through.
was justified
I am not a
here,
threat
or was
to
it
any
too
officer.
harsh?
Why are hands on me?
Yeah.
Why are
I
hands
told
being
you. I
put
told you I was going to put hands on you.
Why are hands being put on? Do y'all see this on the camera?
And right there, put your hands on the wall. Put your hands on the wall because you're not listening. Don't listen. I don't advise that.
Good morning, sir. You're Dan Church.
Oh, yes, ma'am.
And this is 26 DCCR 0612. Mr. Church is charged with deadly conduct, discharging a firearm. And the state has filed a motion asking that, well, I'm looking at the state's motion. The motion it says aggravated assault, but the charge is deadly conduct. That just
I'm sorry, Judge. That's my error. I was
Okay.
trying to file it rather quickly after receiving the affidavit from the complainant, and I'll fill the court in on that as to why I don't have a witness present.
looks like the current bond is set at $20,000. The state has asked to raise that bond. Ms. Malfino?
Excuse me, Judge, and I apologize about that error. Obviously,
That's fine.
the court would see the probable cause affidavit. It's very similar to an aggravated assault, discharging a weapon somewhat in the direction of the complainant. In this case, I have had multiple conversations with Jeremy Shelton, the complainant. He is the across the street neighbor about that
Notice
error.
how
Obviously,
quickly courtroom proceedings can shift
court
from
would
legal
see
arguments
the
to
probable
security
cause affidavit.
concerns.
It's very similar to an aggravated
Once a
assault,
judge issues an
discharging
order,
a weapon,
refusing to comply
somewhat
can
in the
escalate the
direction of the
situation
complainant. In this case,
dramatically.
I have had multiple
And here's the
conversations with Jeremy
irony.
Shelton.
The more someone
the
argues in
complainant,
that
he is
moment, the less control they
across the
often have
street
over the
neighbor,
outcome.
Mr. Church. He is a very nice young man. He was very forthright. Came in and presented me or had an affidavit authored by himself with one of my investigators in lieu of coming to docket today. He, as the court can probably surmise, is of the mind that he doesn't want to aggravate the situation. Nope, not intending to use that same word, but I will tender that as State's Exhibit number 1, just for purposes of this hearing, and I have Mr. Gertz, it's his affidavit just expressing concern about the nature of this offense and the fact that they reside across the street from one another, that he has a very young son and a wife who were also present at the time of this offense, and he is concerned that Mr. Church may be keeping weapons at his sister's house down the street. I have worked very closely with my investigator, Mr. Bays, and he is familiar with Mr. Church as well as Port Arthur Police Department is. And we've asked that some things be implemented in the interim time period to hopefully assure the safety of all the parties, including Mr. Church. I just wanted to bring this matter to the court's attention with that motion. It's not necessarily intended to increase as much as it is to modify with the admonishment regarding weapons, etc., because obviously it's difficult to remove these two individuals from one another approximately because of where they both reside. It's not
Now we're entering
necessarily
a completely
intended
different legal
to
conversation.
increase as much as it is
Bond
to
hearings operate
modify
under
with
different
the
rules than a trial.
admonishment regarding
This isn't
weapons,
about
etc.,
deciding
because
guilt or
obviously
innocence, it's about
it's
balancing public safety,
difficult
the
to
rights of
remove
the
these two
accused, and the
individuals
likelihood
from
that the
one
defendant
another
will comply with
approximately
court
because of where
orders
they
moving
both
forward.
reside.
Any objection to me reviewing that?
Well, Judge, the rules of evidence don't apply in a bond hearing, so I would love to have some great evidence, but I don't have a good one.
Then I'll state the ones admitted for purposes of this hearing. Give me just a second, please. Mr. Gertz?
Judge, I'm happy to discuss bond conditions. $20,000 is more than sufficient, though, in terms of amount for this allegation as it stands right now, or as it's indicted right now. Mr. Church wouldn't, I think, object to the normal conditions of not having any contact with the complainant, not possessing any weapons.
Those are already conditioned.
Right. I'm not sure what else, given what else the court could impose, because of the proximity of their homes without infringing on his constitutional property rights of his own. But I think the fact that he's hired counsel, has shown up to court, he's taken this seriously. He's not been threatening the complainant or anything of that nature. I understand the complainant may have concerns, but those are the complainant's concerns. They're not being triggered by anything, no pun intended, by anything that Mr. Church has done since his arrest or his indictment. And so, and he's not violated any of his bond conditions that
No, I think
that I'm
the
aware of,
concern
or that
is if they feel like he
may have
This is one of those moments that makes
concerns, but
legal
those are the
analysts
complainant's
pause.
concerns. They're not being triggered
The
by
judge
anything,
isn't
no
just
pun
addressing
intended, by
alleged
anything that
criminal
Mr.
behavior.
Church has done
She's
since
trying
his
to
arrest or
prevent
his
future
indictment.
conflict between neighbors
so,
living directly across the street from each other.
And he's
It's
not
an unusual
violated any of his
challenge.
bond
How do you
conditions
enforce
that
a no-contact
No,
order
I
when
think
two
that I'm
people
aware of,
can't
or that
realistically
is if
avoid
they
seeing one
feel
another?
like he is watching, could be, just uncomfortable. There's an allegation that he's sitting in his car watching family, obviously based on the nature of the offense and the allegations and the probable cause. That would give me some concern too if I lived across the street and that had actually happened. So,
but I just don't think raising his bond and just charging him more penalty is the proper remedy for that. So I'm not sure how the court remedies that. I don't see what
the way it gets remedied, Mr. Church, is if you're doing anything that's making the person uncomfortable, that's the complaining witness in this case, the only way for me to take care of that is to put you in jail. Then they don't have to, nobody has to worry. I don't want to do that, but I need you to understand that there's no way around if, you're not contacting them or talking to them. I get that. But if you're doing other things, like sitting in your car and watching them, then that's going to be of concern to me. So I'm ordering you. Here's what I'm ordering right now. Listen to what I'm going to say very clearly, okay? This no contact order is going to include literally looking that direction. You can't sit on your front porch. You need to sit in the back. You can't just sit in your car for no good reason. People don't do that. So you're not going to do that. Do you understand?
Yes, ma'am.
So if they feel uncomfortable, they're going to let Miss Malfino know, and you're going to end up in jail. So I understand you live across the street, but if I were you, I'd walk. If I was going out my front door, get in your car and leave if you're going somewhere. No lingering, no looking that direction, no standing there watching. Otherwise, you're going to end up in jail because I won't have any other choice. Does that make sense?
Yes, ma'am.
Okay. So we'll reset this for an announcement. Make sure you stay in touch with Mr. Gertz, visit with him before that next court date, and we'll see if we can get an announcement. Okay.
Yes, ma'am.
You're free to go.